Hello, everyone, and welcome to Uncivil Law. For today's case, we're going to try to figure out what duty a lawyer owes you in a criminal case. What evidence does that mean that you were denied your rights under the Constitution? This is the case of Strickland versus Washington. In this case, there was a guy who was sentenced to the death penalty, and he argues that one of the reasons he was sentenced to this was because he had a bad lawyer. And so the question the United States Supreme Court was trying to solve in 1984 when this case was decided was, did he have a bad lawyer? And if so, is the fact that he had a bad lawyer something that we need to do something about in terms of this guy getting another trial or a new sentence or whatever? So we have to figure out, what did this lawyer do? Did he do a bad? Let's get started with this. During a 10-day period in September of 1976, the respondent planned and committed 3 groups of crimes, which included 3 brutal stabbing deaths, some mistreatment, being held against a person's will, further mistreatment, further attempting of ending people's lives, threatening people, and theft. So just an all-around great guy. During this 10-day period, he did many, many bad things. After 2 of his accomplices were arrested, the respondent surrendered to the police and voluntarily gave a lengthy statement, confessing to a third of the criminal episodes. So, this guy was arrested and he confessed to at least a third of all this stuff. So that's good news. The state of Florida indicted the respondent for the kidnapping and the murder and appointed an experienced criminal lawyer to represent him. So, this guy has gone on a 10-day bender where he has committed 3 different stabbing murders, torture. Now he's being appointed an experienced criminal lawyer who has to help represent him. So the criminal lawyer has his work cut out for him. But wait, it gets worse. It gets worse. And you're thinking to yourself, how could it possibly get worse for this defense lawyer, man? I mean, he's already confessed to the police and everything. How much worse can it get for this defense lawyer? Let's find out. The attorney actively pursued pretrial motions and discovery like a good attorney. The attorney, however, cut his efforts short, and he experienced a sense of hopelessness about the case when he learned that, against his specific advice, he also confessed to the first 2 murders. So, okay. Wow. So, yeah. So this guy is represented by a lawyer. And his lawyer says, what would be great? It would be great if you didn't confess to the first 2 murders. And you know what his client said? I think what would be great is if I confessed to the first 2 murders. He's like, wait, what? That doesn't sound like that's going to be that helpful. I'm trying to represent you. I'd like you to not confess to the first 2 murders, please. And he says, no, I'm going to disregard your advice and I'm going to specifically go against it and I'm going to confess to the first 2 murders. And then his lawyer says he feels a little hopeless. Why would his lawyer feel hopeless in response to this ongoing stuff? It's time that by the time of trial, the respondent was subject to indictment for 3 counts of first-degree murder and multiple counts of robbery, kidnapping for ransom, breaking and entering, and assault, attempted murder, and conspiracy to commit robbery. Things are not going well. The respondent, then making defense lawyer's life even better, then waived his right to a jury trial against his lawyer's advice and pleaded guilty to all the charges, including the 3 murders. So, it would be super helpful if we had a jury trial. No, I don't want a jury trial. Wait, what? Okay, well, at least, you could plead innocent. No, I want to plead guilty. The defense lawyer is having a tough time here, man. As an attorney, I feel bad for the other attorney, right? His client is scum of the earth. So I don't feel bad for the client. The client is getting what he deserves. But I can't feel bad for the attorney because the attorney is trying to represent this guy. And he's like, what would be helpful if he didn't confess to the murders? I'm going to confess to the murders. What would be helpful is if we had a jury trial. How about not a jury trial? What would be helpful if you pleaded not guilty? How about guilty? And his lawyer is feeling a little bit despondent, feeling like it's not going super well. Why would he feel that way? But it gets even worse because his attorney advised him to invoke his right under Florida law to advisory jury at the capital sentencing hearing. Okay, so just what you need to know here is, by law, you are entitled to a jury even for sentencing in a capital case. There was a U.S. Supreme Court case over it specifically, and said that you're entitled to a jury for the purposes of sentencing. So even if you waive your right to a jury for the purposes of the conviction, you're still entitled to a jury for the purposes of the sentencing. So you can waive your right to a jury for the underlying conviction and still say, I want a jury for the sentencing. And his lawyer said, how about a jury for the sentencing? And he said, how about not that? How about not that? How about I just don't have a jury there too? So he rejected that advice and instead chose to be sentenced without a jury recommendation. So that seems like good. Let's just keep not doing what my lawyer was. That's helpful. The lawyer decided not to present and hence not look for further evidence concerning character and emotional state. Okay, that decision reflected trial counsel's sense of hopelessness about overcoming the evidentiary effort of the confessions to the gruesome crime. So his lawyer said, okay, I'm just not going to look for evidence that would help on the character and emotional state. Why am I not doing that? Because of the many, many confessions? Yeah, it's not going well. It also reflected the attorney's judgment that it was advisable to rely on the plea colloquy for evidence about the background and about his claim of emotional stress. The plea colloquy communicates sufficient information about these subjects, and foregoing the opportunity to present new evidence, counsel prevented the state from cross-examining the claim and putting on psychiatric evidence of its own. So one of the things that the lawyer is doing is the plea colloquy is the standard set of questions the judge has to ask you. Questions like, do you understand that you're pleading guilty? Do you understand a plea of guilty is the same as being sentenced to by a jury? Do you understand that I can sentence you to anything that you could be sentenced for if you were found guilty? Do you understand that you're waiving the right to remain silent? Do you understand that you're waiving the right to call witnesses on your own behalf? Do you understand you're waiving the right to discovery? And so forth and so on. Do you understand the maximum penalties? That's the plea colloquy. All right. And so the judge asks a lot of questions. And his lawyer was saying to himself, okay, there's enough evidence during this plea colloquy for the judge to understand my client's emotional state. I don't need to call witnesses or stuff. And if I did, it would come with negative consequences. The government would be able to cross-examine that. So right now, the government can't cross-examine that because he's not testifying. He's just answering these routine questions that have to be answered. So he's like, the judge has enough information. The government can't cross-examine that because there's nothing to cross-examine. If he testified or someone testified, they could put on more evidence about his emotional state and mental state. And that would just make things even worse. So I'm not going to look into it because it can only go downhill from here. Seems like a reasonable course of decision to me. The attorney argued that his client should be spared the death penalty because he had surrendered, confessed, and offered to testify against a co-defendant, and because he was fundamentally a good person who had briefly gone bad in extremely stressful circumstances. So, yeah, this is, this is one of those times where it's like you just have to hope that no one calls you on your BS because, you as an attorney don't have a lot to work with in these circumstances. So you're like, okay, you should spare him the death penalty because he confessed. He offered to testify, and also because he's just fundamentally a good guy who had a bad 10-day period. It may not pass the left test, but in these circumstances, what else can you do, man? What else can you do? The trial judge, however, was not super impressed. He found many aggravating circumstances, such as the triple murders with the stabbing, and the kidnapping and the extortion. And therefore, with respect to each of them, the trial judge concluded that there is aggravating circumstances and insufficient mitigating circumstances and sentenced him to death. And the Florida Supreme Court upheld the convictions on review. So the guy gets the death penalty for the 3 brutal stabbing murders for his very, very bad weekend. His 10-day long weekend. Yeah, that's great. So the client over here would like to not be sentenced to death very much and is bringing a complaint on this and saying, my lawyer did a bad job. Now, right away, this may go to my biases as a lawyer. Maybe this goes to my biases. But I'm trying to put myself in his lawyer's shoes. And I'm trying to say, would I have done anything different? And my initial answer is no. I tried to give my client really good advice, and he tried to defy that. And it's like, if I did things, it can only get worse from here. He could put on cross-examination, so I feel like I have enough, and yeah. And so I'm like, yeah, that seems about right. And now he's saying, oh, I should have not gotten the death penalty. You know what would have helped with that? You know what would have helped with the not getting the death penalty? What would have helped is if you had followed my advice about not confessing to the other murders, and you had not waived your jury trial and had not confessed and had not pled guilty and stuff. That would have helped a lot. But you ignore my advice, and so I don't know what to tell you. But apparently I was supposed to tell you something different. I don't know what that is. So let's read about why he's sad about, his conviction for the triple stabbing murders and stuff. The respondent sought collateral review in state court on numerous grounds. So having exhausted his appeals, he's now coming at it from the side. So he's trying a collateral attack, which courts really dislike. So he's arguing that counsel had rendered ineffective assistance at the sentencing. What? Respondent challenged his assistance in 6 respects. He asserted that the lawyer was ineffective because he failed to move for a continuance to prepare for sentencing. Like how? To request a psychiatric report. Don't want to do that. To investigate and present character witnesses. That was going to go over well. To seek a pre-sentencing investigation report. No. To present meaningful arguments to the sentencing judge and to investigate the medical examiner's report or cross-examine medical efforts. In support of the claim, respondents submitted 14 affidavits from friends, neighbors, and relatives, stating that they would have testified if they asked them to do so. Which, it comes with its own downsides. So there's reason maybe not to have those people testify. I understand these strategic decisions. He also submitted 1 psychiatric report and 1 psychological report stating the respondent, though not under the influence of extreme or emotional disturbance, was chronically frustrated and depressed because of his economic dilemma at the time of the crimes. Which, last time I checked, is not a valid defense. I was chronically frustrated from the economic dilemmas, so that made the triple murders legally, okay or something. And I was deficient for not presenting this report about how you were not insane, but you were just frustrated. I was incompetent as your lawyer for not presenting this report. I don't think so. The court rejected the challenge to counsel's failure to develop and present character evidence, you don't say. The affidavit submitted in the collateral proceedings showed nothing more than certain persons would have testified that the respondent, who, remember, is the triple murderer, was basically a good person who was worried about his financial problems. Okay. So, yeah, if we had allowed these 14 people to testify, these 14 people would have said, this is fundamentally a good person. How do you think that would have worked out? 14 people saying, this is fundamentally a good person. Despite the triple stabbing murders and the kidnapping with ransom demands and the extortion and the attempted murder and the other minor violations, but 14 people are willing to say he's a good boy. And his lawyer said to himself, you know what? I don't think these 14 people are going to be particularly helpful in my case. Does that seem like the kind of decision a lawyer could reasonably reach? These 14 people are not actually going to help my cause very much. Let me not call them to the stand. Seems like a very reasonable decision to me. Seems pretty reasonable. I could understand a lawyer making a different decision, but this decision also strikes me as pretty reasonable. The respondent himself had already testified along these lines at the plea colloquy. So, again, his lawyer is thinking, well, these guys are just repetitive, because he's already said these things during the plea colloquy that the government can't cross-examine. So why, introduce these people who can be cross-examined, just let the statement stand on their own? Seems plausible. Respondent's admission of the course of stealing rebutted many of the factual allegations in the affidavits. So his own confession rebutted what these people said. These people said, he ain't done nothing wrong. You know who disagrees with you? The guy you're testifying about. That's someone who disagrees with you. He ain't done nothing wrong. He says he has. For these reasons, and because the sentencing judge stated his death sentence would be appropriate even if he had no significant prior criminal history, yeah, the fact that you were a good boy up to this point, it's like, I don't know what to tell you. No subsequent prejudice resulted from the absence of sentencing of character offered in this collateral attack. Yeah, these 14 people who would have... The court agreed the Sixth Amendment imposes on a lawyer a duty to investigate because reasonable effective assistance must be based on professional decisions and informed legal choices that may be made only after investigation of options. The court observed that the counsel's investigatory sessions must be assessed in light of the information known at the time, not in hindsight and in light of the realities of trial. If there's only one plausible line of defense, the court concluded counsel must conduct a reasonably substantial investigation into that line of defense, since there can be no strategic choice that renders such an investigation unnecessary. The same duty exists if counsel relies on only one line of defense, although others may be available. In either case, this investigation need not be too exhaustive, but it must include independent examination of the facts, circumstances, and pleading in law. Yeah. If there's more than one plausible line of defense, the court held counsel should ideally investigate each line before it makes strategic choices. If counsel conducts such a substantial investigation, these choices made as a result will seldom, if ever, be found wanting. Because advocacy is an art and not a science, and it's also unclear what we could have done that would have made any difference in this world. And because the adversary system requires deference to these choices, strategic choices must be respected. If counsel does not conduct an investigation in each line of defense, assistance may nonetheless be effective. Counsel may not exclude certain lines of defense for other than strategic reasons, which, there are plenty here. There are strategic reasons not to look down these lines. Limitations on time and money may force strategic choices, often based on conversation with defendant and review of evidence. Those strategic choices about which line to pursue are owed deference with the reasonableness. Thus, when counsel's assumptions are reasonable, given the totality of circumstances, and when the strategy represents a reasonable choice, counsel need not investigate lines they've chosen not to employ. So, yeah, a lawyer has a duty to investigate all the lines that seem like they might lead anywhere because you're trying to do your duty to your client. And the lawyer's like, I didn't look into this stuff because there was just no way it was going to help. And also, for strategic reasons, I don't want to do it because there's disadvantages to this. If I get this report, it's not going to help, and it can be I understand it's not going to help. And also, he's already kind of said all this stuff during the plea colloquy, so the judge already knows it anyway. So to the extent it's going to make any difference, it's there. So yeah, I'm not going to. Also, you defied my advice by confessing and pleading guilty and waiving your rights to trial and stuff. So it's don't have a whole host of options here. So just relying on the plea colloquy seems like a reasonable option. The court's like, yeah, you need to look into the options that are reasonable, but if there are reasons strategically not to do that like you have here, then you don't have to do things that are not strategic. And the lawyer's like, right? There's no reason for me to do this because it wasn't going anywhere. In a long line of cases, the Supreme Court has recognized a Sixth Amendment right to an attorney exists and is needed in order to protect a fundamental right to a fair trial. A fair trial is one in which evidence is subject to adversarial testing and is presented to an impartial tribunal for resolution of issues defined in the advance of proceeding. The right to an attorney plays a critical role in this system embodied in the Sixth Amendment, since access to a lawyer's skill and knowledge is necessary to afford defendants ample opportunity to meet the case of the prosecution to which they are entitled. The Supreme Court has recognized that the right to counsel is the right to an effective assistance of counsel. The Supreme Court has not elaborated previously on the meaning of constitutional requirements of what effective assistance of counsel means. That is, what those claims of actual ineffectiveness would look like. In giving meaning to the requirement, we must take note of the purpose, to ensure a fair trial. The benchmark for judging claim of ineffectiveness must be where the conduct so undermined the proper functioning of the process that the trial cannot be relied on as having produced a just result, which doesn't seem like it's present in this factual circumstance. Seems like we were doing the best we can with very limited resources, mostly because of our own client, who, made our lives hard. Representation of a criminal defendant entails certain basic duties. An attorney's role is to assist a defendant, and an attorney owes a client a duty of loyalty and a duty to avoid conflicts of interest. A lawyer also has a duty to bring to bear such skill and knowledge as will render the trial a reliable testing process. So a trial needs to be able to function as a trial, which means, in part, doing your job. Yeah. Unfortunately, the decision as to whether or not to plead guilty, the decision as to whether or not to have a jury trial are solely issues within the defendant's control. So the lawyer can do absolutely nothing about it. It's like, yeah, you can plead guilty. I can't stop you. So yeah, oh well, that's on you, I guess. In making the determination, a court hearing an ineffective assistance claim must consider the totality of the evidence before the judge or jury. Some factual findings will have been unaffected by any error, and factual findings that would have been affected will be affected in different ways. So the errors your lawyer makes would cause different things to occur. Some errors might have a pervasive effect on inferences to be drawn, altering the evidentiary picture, and some will only have an isolated effect. So some errors might be more important than others. Yeah, deep thoughts. So far, we have learned many things about the role of a lawyer. A lawyer's job is to zealously represent his client and is to do the best he can. A lawyer's job is to investigate any potential lines, conflicts, and to give sound advice. So these are the jobs of a lawyer, right? Give good advice for strategic reasons, not because of incompetence, and so forth and so on. So yeah, this should all sound pretty familiar to anyone out there who's gone to law school, or anyone who just thinks about what are the jobs of a lawyer. Well, it's roughly the same as the job of a doctor in this way, or the same job as any sort of professional. You know, be competent in your field, make sure that you're giving good advice, look at the lines of inquiry, make strategic calls, pursue those lines that look most reasonable, right? Kind of like just the jobs of a professional of pretty much any field, really. So now we have to figure out, did this lawyer screw up any of those responsibilities? So let's figure that out. Having articulated these standards for judging ineffectiveness, we think it's useful to apply these standards to the facts of this case in order to illustrate the meaning of the general principles. Yeah, so having explained what the role of a lawyer is, let's see how it applies to this case. Application of these principles is not difficult in this case. It's really not. The facts as described above make clear the conduct of the lawyer at and before the proceeding cannot be found to be unreasonable. Seems perfectly reasonable to me. With respect to the performance component, the record shows counsel made the strategic choice to argue for extreme emotional distress as a mitigating circumstance and to rely fully on possible of the acceptance of the crime. So basically, going with the principle of throwing yourself on the mercy of the court, which is a valid option. You know, throwing yourself on the mercy of the court. Yeah, that works as an idea. Although counsel understandably felt hopeless about these prospects because there was no hope, nothing in the record suggests that the counsel's sense of hopelessness distorted his professional judgment. So he was doing the best he can in a hopeless world. The lawyer's strategic choices were within the range of reasoned judgments, and the decision not to seek more character or psychological evidence than was already in hand was likewise reasonable. It's like, yeah, if I had done more, it wouldn't have helped. It raises its own set of problems, and I already kind of have what I need. So let's just go with that and, go with God. And, it didn't really work, I guess, but what else can you do in these circumstances? The trial judge's views on the importance of owning up to one's crimes were well known to counsel. So the lawyer knew the judge thought that taking responsibility was a good thing. And so, maybe the lawyer's thinking to himself, this judge thinks that someone taking responsibility for themselves is good. So maybe if this guy takes responsibility for himself and doesn't try to offer this mitigating evidence, maybe like I wasn't responsible, maybe that will please the judge and he will not sentence my guy to death because he likes it when people take responsibility. Yeah, he does like it when people take responsibility, but he also dislikes the triple stabbing murders. So, that there was that reasonable call. The aggravating circumstances were utterly overwhelming. Yeah, the triple stabbing murders and attempted murders and kidnapping with ransom and extortion and it was going well. Trial counsel could surmise from these conversations with his own client that character and psychological evidence would be of little help. So why did he think that character and psychological evidence would not help? Because he had the misfortune of actually talking to his client. And he's like, oh, Oh, no, that's not going to work. The defendant had already been able to mention at the plea colloquy the substance of what he knew about the financial and emotional troubles. So he already mentioned I was down on my luck and wasn't feeling great about myself. And you know what I thought would make me feel better about myself? You know what would make me feel better? Triple murder with stabbing. The stabbing is part of my therapy. Great. The restricting testimony on the character to what had come in this plea colloquy ensured the contrary evidence would not come in. So he's testifying at this plea colloquy, but it's not really testimony in the strictest possible sense. So there's no cross-examination, right? So it's just part of the judge making sure that you understand the charges and what you're doing and stuff. And as part of that, he's saying, I felt out on my luck. I was having financial trouble. I felt really, really frustrated. You know what helps with the frustration? The triple murders. And so all that was already out, and the prosecution couldn't cross-examine. And the lawyer's guy said to himself, you know what? If I offer evidence as to this in a more formal way, they can cross-examine it, and it's probably not going to help because I've talked to my client, and no. So I don't want to go down that road. Seems pretty reasonable to me. On these facts, there can be little question, even without the application of presumption of adequate performance, that the defense, though unsuccessful, was the result of reasoned professional judgment. Seems pretty reasonable to me, man. I don't know what else you're supposed to do here. You know, there wasn't a lot of great options in this circumstance. With respect to prejudice, which is to say, even assuming that the lawyer screwed up, did it matter? That's prejudice, right? So let's take for granted for a moment the lawyer screwed up. Let's assume the lawyer screwed up. Did it make a difference? So let's analyze that. With respect to whether it would have made a difference, the lack of merit of the claims is even more stark. So it's even worse. It's even worse. So we don't think the lawyer screwed up, and even if he did, it didn't matter. There's even less evidence that it mattered. The evidence the respondent says his trial counsel should have offered would barely alter the sentencing profile presented to the sentencing judge. As the state courts and the district court found, and most of the evidence shows, that numerous people who knew the respondent thought he was generally a good person. Okay. Yeah, and that a psychologist and a psychiatrist believed he was under considerable emotional stress, but it didn't rise to the level of an extreme disturbance. Yeah. Given the overwhelming aggravating factor, there's no reasonable possibility that omitted evidence would have changed the conclusion that the aggravating circumstances outweigh the mitigating circumstances, and hence the imposed. Yeah, the Supreme Court of the United States is saying, we don't think the trial judge would have been super impressed with the 14 people saying, our boy didn't do nothing wrong, he's a good boy. And wouldn't have been super impressed with a psychiatrist report saying, my client was feeling some stress that day. He was sane, but he was feeling stress. Supreme Court saying, we're not feeling that would have made a huge amount of difference. In fact, the admission of this evidence now would have been even more harmful to the case because, again, his lawyer's not an idiot, and he realizes if he had done that, that would have come with negative consequences. What kind of negative consequences? Well, his rap sheet would have probably been admissible into evidence because now it's contrary evidence, right? So if he admitted, his lawyer kept out some of his prior bad acts. Good job. And now he's thinking, oh, if I have these people testify, he's a good boy who ain't done nothing wrong. Maybe he ain't done nothing wrong. Well, that's really interesting because I have this document over here that proves he's done some things wrong. Yeah. So maybe we don't want that in when the judge is considering things. That sounds like a good idea. And the psychological reports. So the psychological reports from the psychiatrists who said, oh, he's feeling stress, would have been directly contradicted by the claim of emotional disturbance applied to the case. Yeah, so, he would have gone directly against your own theory of the case, so no. None of those things. Failure to make a required showing of either deficient performance or prejudice defeats the ineffective claim. His lawyer was doing the very, very best he could in a very difficult world. Here, there is a double failure to this claim. More generally, the bad guy has made no showing that the justice of his sentence was rendered unreliable by a breakdown in the process. and rendered it unfair assistance. The sentencing process was therefore not fundamentally unfair. So that is our end of our discussion of Strickland versus Washington, a case where a guy called Washington had a very bad 10 days. He was under some stress and some financial pressure, and he thought, you know what would make me feel a lot better? Triple stabbing murders, attempted murder, extortion, kidnapping with ransom. That would make me feel better. And you know what would also really help? My lawyer says I shouldn't plead guilty to the other murders. You know what I think I should do? I should plead guilty to the other murders. And my lawyer says I should have a jury trial. You know what I think? I shouldn't have a jury trial. And my lawyer says I should plead not guilty. You know what I think? I think guilty is better. And his lawyer says, I feel hopeless. And then his client says, aha, I've got him. Ineffective assistance of counsel because my lawyer felt hopeless. And the Supreme Court looks at this and is like, really? 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 You really think that the 14 people who said you were a good boy would have helped, even though we have a long record that would have come in to prove the opposite of that thing? And you think the psychiatrist who said, you know, it wouldn't have helped to say I wasn't under emotional distress. So I was trying to argue extreme emotional distress, but if I had presented this psychiatrist report, which was my own psychiatrist, incidentally, who says the exact opposite, that there wasn't extreme emotional distress, that would have helped. And extreme distress, when you're trying to argue you're under extreme distress, would have helped your case very much. I think admitting the report that says you were not under extreme distress when you're trying to claim you were under extreme distress might have hurt your case. That sounds like that would not have helped. That sounds like it would have hurt. And so your lawyer didn't do a bad by failing to admit a report that goes directly against your only sort of mitigating factor. I was having a bad day, and the report is like, no, you weren't. So they didn't screw up, and also the 14 witnesses would have helped and also would have led your record. So yeah. So no, we learned the duty of a lawyer, and we learned that this lawyer didn't screw up, and that's the end of the coverage of this case. Takes opposite day very seriously, man. Yeah, that's true. My theory is that I was under extreme emotional distress, and my lawyer did a bad by not admitting the psychiatrist evidence that says I wasn't under extreme emotional distress. I wish they had admitted the evidence that said I wasn't under extreme emotional distress. That would have helped my claim that I was under extreme emotional distress. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to the channel. Cheers and goodbye.